You've sued your doctor for medical malpractice, and the defense has told you from the very beginning they are never negotiating with you. But as your case is finally coming up for trial 2 or 3 years down the road, now all of a sudden the defense tells your attorney, hey, we'd like to try and negotiate. And you say in response, you know what? One of the conditions that I have in order to begin negotiating is that I never want my doctor practicing medicine ever again. Do you think the defense will go along with it? Do you think they will agree to something like that? You want to know the answer? Come join me for a moment as I share with you exactly what's going to happen. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so now you believe that your doctor was careless and caused you significant harm and injury. And as a result, you brought a lawsuit against him. And a medical expert confirmed that, in fact, the doctor was careless, and his carelessness was a cause of your injury. And now the doctor in response said, hey, why are you suing me? I did nothing wrong. And by the way, if I did something wrong, so did you, Mr. Patient. And then he says, you know what? If I did something wrong, whatever I did didn't really cause or contribute to your injuries. And then he turns around and says, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. Those are the typical defenses that we see in these medical malpractice cases. So now they turn around and say, you know what? We are so outraged that you have decided to sue us. We are never, ever going to negotiate with you. We're never going to settle this case. That means we'll see you at trial. We're going to let a jury decide whether you are more likely right than wrong. It takes 2 to 3 years to go through the entire litigation process for you to get to trial. But something interesting happens. Now, as you get closer and closer to trial, within about a month or maybe even a few weeks before trial, the defense lawyer calls your attorney and says, hey, listen, we've reevaluated this case. We'd like to begin talking and negotiating. Your attorney calls you and tells you that now the defense is willing to talk. And you say, that's great. They've taken 2 or 3 years out of my life. Now they're willing to talk. The only way I'm going to talk, the only way I'm going to allow you to negotiate on my behalf is if one of the conditions of settling this case is that this doctor whom I sued never ever practices medicine again. If he agrees to that, I will go ahead and begin negotiating. What do you think your attorney's going to say? Your attorney's going to say, that's not happening. It's never going to happen. Because even if he agrees with you that what the doctor did was so outrageous and caused you significant harm and injury, the whole purpose of bringing this type of lawsuit against your doctor is, number one, since he was careless and caused you harm and injury, you can't go ahead and have him put you back together. They can't put the pieces of the puzzle back together to make you whole again. So the only thing that we have in our system of justice is an attempt to obtain money as a form of compensation for all of the harms and losses and injuries that you suffered. It is not to have the doctor's license revoked. It is not to destroy the doctor's reputation. It is not to prevent the doctor from ever practicing medicine again. And I understand the frustration that you have, and I understand your desire to want to make sure that this never happens to another patient again. But you know what will happen if your attorney goes back to the defense lawyer and says, listen, we're willing to negotiate, but if one of the conditions of settling your case is that the doctor can never practice medicine again, you know what the defense lawyer will say? Take a hike, we'll see you at trial. That's exactly what will happen. So let's say you do go to trial, right? And now you tell your attorney that you want the judge to give the jury an instruction, a legal instruction at the end of the case, that when they come back, if they come back and find in your favor, that one of the things that they should be considering is that this doctor should never be allowed to practice medicine again if they rule in your favor. And you know what your attorney will say? Well, that's wishful thinking, because nothing in this lawsuit will permit you to ask the judge or to ask the jury to make sure this doctor never practices again. You know, there is one tiny exception, and it doesn't have to do with your particular lawsuit. If this doctor's actions were so outrageous, so egregious, and intentional, there is the possibility that the New York State Department of Health will find in their own separate investigation that his ongoing activity, his ongoing treatment of patients, may be an imminent threat to the general public. If they reach that conclusion, then yes, they will go ahead and either temporarily revoke the doctor's license to practice or permanently revoke his license to practice medicine. That may be the one small exception where somebody turns around and says, hey, this doctor will not be allowed to practice medicine again. So why do I share this great information on a beautiful day here in Great Neck? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit and still have questions about your matter, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.